Now back to the show. This is The Law Show on CL 650.
One break my heart, say you love me again. Undo.
And welcome back to The Law Show on CL 650. I'm Zach Spencer along with David Halkett and Leah Donaldson from McQuarrie LLP. And we were talking about children, breaking up a family in the family law department you have there at McQuarrie LLP. Now, with children, we've talked about this in the past. Depending on the age of the child, it might vary about how custody is done. So, kind of walk me through that again. You know, newborn children with going to need to be with mom, right?
So 0 to 1 years, usually they're going to be majority with mom, who's probably going to be on mat leave, and dad will get a number of times a week for short periods of time. More often for shorter periods is what the normal rule of thumb is. For 1 to 5, as they get closer to 5 years old, you have a better chance to have them more of a shared situation. So maybe by two they start to getting some overnights. Then it works up to the weekends and such. After 5, you can get a more shared regime. And once they get 12 or 11, 12, 13, pretty well the children can choose what to some extent what they want. It's not ultimately their choice, it's the parents' decision, but we listen to them and often will abide by what they want.
All right. So with children, the best interests are to have both parents nearby.
Yes.
Right. So does the law look at this and say you need to be nearby? Like, how does it work when somebody maybe wants to move away? Maybe they've met a new partner and, maybe the mom lives in Chilliwack and the new partner and husband are going to be in Victoria. That's not exactly nearby.
Yeah. So the court looks at the only test they look at is what's best for the children. Best interest of the children is the only test that the court considers. So what was the regime before when determining whether or not a move would be in their best interest? If they were in equal shared time, it's, you have to show that it would be better for the children to move, because if you're moving outside a range where you can actually still maintain that equal time, one party is going to be losing out time with the children, and it's not usually best for the children. So it's really a difficult area to advise in because the case law is all over the place. It's very fact specific.
So does it ever happen where the judge says, sorry, you can't move?
They say you can move, but you can't take the child. So you'll lose out on your parenting time if you move there. And as David said, it's very difficult to advise on because no two cases are similar. We see lots of overlap, I would say, in the more straightforward ones. But so the factors that the court looks at are, maybe usually people are moving for jobs often, a new partner, extended family, where they're located. So there's a lot of factors that go into this assessment that a judge makes. But at the end of the day, it's a high stakes game where there's so many moving parts that it's hard to predict what a court will do.
Now, what about the sort of the boundaries? What is, someone might say, well, I live in Chilliwack and he's moving to Vancouver, and they might go to court and go, well, you're moving away. Well, you're still in the greater Vancouver area. So what is far away?
Well, it's interesting that you asked that question, Zach, because I was in a matter once, and this was 5, 6, 7 years ago, and they lived in Langley and Surrey, so the equal shared was working.
Which doesn't seem far.
No. But then one party wanted to move out to, I think it was east part of Abbotsford. And we thought that was like way too far. The judge that was hearing the case lived out there. He said, well, it's still within the Lower Mainland. So we didn't think there was a problem, even though it really does throw a wrench into the visits, because the travel time can be, especially Friday afternoons, driving out Highway 1 to go and pick your child up. Normally we consider the greater Vancouver area as one area. It's when you're moving outside, say, the Lower Mainland, that it becomes a move. So if you're moving to Kelowna would be a move, Victoria could be a move.
Even Whistler would be.
Yeah, that could be considered outside as well.
Okay, so what do you say to your clients when they come in and they say, I've met somebody new and they want me to move to Victoria?
I usually say that the situation that was established at the time of the birth of the child or your relationship before is the de facto situation. So if you live in Langley, then that is basically the de facto area that the child needs to live. The person that wants to move away, it's their burden, we say. They have to convince a court to allow them to move unless the party agrees. So you can give, the legislation actually requires you to give the other parent notice of the fact that you intend to move, and then they can either agree or they can contest it, and then that party that wants to move has to make a court application.
Okay, let's talk about, say somebody has the child more than the other, and they want to move away and take the children away from the remaining spouse.
They still have to give notice under the Act, and you have to give 60 days notice prior to the move, and the other person has 30 days either to oppose, agree, or file a claim to prevent the move. If you have more than shared, if you have the majority of the time and you make a legitimate, reasonable offer to the other party to keep up their relationship with the child, then it's up to you. It's not up to you to prove that it would be a good move. It's basically assumed. If it's a shared situation, then you have to show that it would be good and best interest of the child. It's so fact specific. It's very difficult, but as Leah said, it's a difficult one to settle because there's no real resolution on a lot of these matters. It's a zero-sum game.
It's a bit heart-wrenching, isn't it? Yeah.
Exactly.
Now, have you ever had a spouse take the children on a vacation overseas and never come back? Have you ever had one of those? Not
overseas, but I did have one go to Quebec once, right around Christmas time, and say that I'm just going there for a week, and then, I'm staying here. I'm not coming back, and had to fight an order here, get an order, have it enforced there.
But you're in the same country.
Exactly. Overseas can be difficult because some countries do not recognize orders from outside their own country. So Japan is a tough one. If it's happened in a lot of cases where someone has been married to a Japanese national who moves back and says, I'm not coming back, and their courts do not recognize our orders. So it's very difficult when there's travel plans to another country that it takes a lot of trust to assume the person will come back.
And do you have any kind of agreements that you can write up when somebody wants to take a child outside of the country?
Oh, yeah. Yeah, we can do that and say that they're going away for this amount of time. I'm consenting to them being gone from X time to X time on this itinerary. It doesn't come to us that often simply because the parties often work it out between them. They've already been divorced and separated. But certainly there are times where you want something a bit more, like even order that they can go away for this time and come back so that at least that you have an order in place that they're supposed to return that you can try and enforce in a foreign court.
So how much do you think people who are getting divorced fight through their kids? I think anybody that's gone through divorce, you kind of feel like the pawn in the middle, right? And do you get that still where people are really mean-spirited through their kids?
We do. We still get that, unfortunately. I think one example that I was thinking of as David was talking is the vacation issue. So oftentimes one parent will want to take the child on a vacation to the United States. So it's a low-risk country in terms of, them disappearing. Flight. It's to Disneyland. It's clearly a child-themed trip that would benefit the child. And, there's no reason not to allow them to travel. And often we have clients say, I don't want them to go because I want to be in control of things or I'm not comfortable with it. And the reality is when you go into court on those matters, most judges want to see that child travel. They want to see them have that opportunity. They're not going to take that opportunity away if there's no flight risk, if there's no reason that they would stay, they have no ties to the country, it's not very often that a court would block that kind of trip.
Yeah, it's rare that you may get some makeup time if you're losing some time, but if you go in with an itinerary, it says I'm flying from here to Los Angeles, I'm staying at this hotel in Anaheim for X amount of time using Leah's example, and then you're flying back, it would be pretty difficult to win an argument that the child shouldn't be able to go.
After going to Disneyland at spring break, I can say my condolences. Good luck with that. Because if there was one person there, there was 1 million people there.
Oh, yeah.
And it's like, yeah, that's not exactly what I call it.
That's half the fun of those places.
No, that's what I was going to say. That's not what I call a vacation. But hey, that's just my personal point on it. Trust me, if I had my kids down there, I'd be on the next flight back.
Yeah. Well, they always say the happiest place on earth where every kid's crying and screaming.
Yeah. And the washrooms are a mile away. All right, so Last thoughts on when you're going through this situation. I know what your answer is going to be. Come and see a lawyer.
Yeah. Well, I think you should get advice before you do anything. Either leave your spouse or do anything with the assets if you're thinking of leaving, because there may be ramifications to everything you do. What you may think the law is may not actually be. And at our office we have the experience and the knowledge to be able to tell you what the law is and what the likely results will be. And you should get advice before you do anything.
I would second that. Nothing to add.
Nothing to add. All right. Well done. Thank you very much to both David Halkett and Leah Donaldson from Macquarie LLP. It's been a great conversation. Always fun having you in, and we look forward to it in the future.
Thanks for having us.
Thanks.
That's all the time we have for today's show. I'm Zach Spencer. We'll speak to you next time on CL 650.